open the hearing on House Bill 2536 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2536 would provide sexual assault survivors with certain rights. The bill would enact a new section of law providing that survivors of sexual assault have the right to consult with a sexual assault counselor and have a support person of the survivor's choosing present during any medical or physical examination or an interview by law enforcement or by an attorney. Before a medical provider would be able to perform a medical evidentiary or physical exam, that would include the collection of a sex assault kit. The medical provider would have to inform the survivor of the survivor's rights by providing the survivor with a document of those rights that would be created by the Attorney General's office. They would have to inform them of the survivor's right to consult with a sexual assault counselor unless one's not available in a timely manner, and the right to have a support person present, and also the ramifications of delaying an examination if the sexual assault coordinator, counselor, or support person cannot be available in a timely manner. And they would have to inform them of the victim's right to shower at no cost after the examination unless shower facilities are not available. Before a law enforcement officer, prosecutor, or defense attorney would be able to interview a survivor, they would have to inform the survivor of the Bill of Rights for Crime Victims under the Crime Victims Compensation Board statutes, the right to consult with a sexual assault counselor, to be called by the officer or attorney before the interview unless one's not available, the right to have a support person available during the interview unless the officer or attorney determines that the presence of that person would be detrimental to the interview and the person consents to the absence of that support person. And they would have to inform the gender of the survivor's choosing unless no officer of that gender is available and the survivor consents to being interviewed by an officer of another gender. When a law enforcement officer or medical provider initially interacts with the survivor, that officer or provider has to provide the survivor with a document developed by the Attorney General that explains the rights of the survivor. That document has to use plain language, be accessible to people with visual disabilities, and also be available in English and in Spanish and on the Attorney General's website. The document has to include a clear statement that the survivor is not required to participate in the criminal justice system or receive an examination to maintain their rights that are provided for in this act, the telephone number or website of nearby sexual assault service providers and counselors, forms of protection, including any protection orders available to them, and information related to compensation funds or restitution. On a written request of the survivor, a law enforcement officer shall furnish a complete copy of all law enforcement reports concerning the sexual assault free of charge to the person. And then also on written request of a survivor, a prosecutor would be required to provide notice of any pre-trial disposition in the case, the final disposition, the time and place of any incarceration, if that's applicable, a defendant's location, and the defendant's information on the offender registry. Subsection E provides that a survivor has the right to have retained counsel present during any stage of an examination, interview, investigation, or interaction with the legal or criminal justice system. Subsection F provides that a survivor who is aggrieved would have a civil cause of action against someone for violation of this act. They would be able to bring a civil action in an appropriate district court for injunctive or other equitable relief. And then finally, subsection G provides definitions for sexual assault counselor and survivor. And I can take any questions.
Do you have any questions for Natalie? Very good, thank you. Committee, I have 3 proponents listed to be on WebEx, but I don't see any of them. Is anyone on WebEx here as a proponent today? Anyone here in person that intends to be a proponent? Okay, so committee, we have lots of written proponent testimony. You'll see we have some from ks.gov, Sabrina Sivert, Caitlin Ryan, Flannery Houston, the Johnson County Sheriff's Office, Samantha M. Let's see, Amanda, actually, that one's from RISE, and then Representative Megan Lynn. So those are the proponents. Yes, Representative Hoheisel.
Thank you, Mr. Chair. I just received an email 5 minutes ago from one of the conferees that says they have not yet received a link to join.
Okay, hold on. We're going to get that fixed. Maybe we have these for just a minute. Let them.
This is already included. Well, ask Natalie. Can I just ask Natalie? Is it? Mr. Chairman, could I ask Natalie a question since we're kind of at ease?
Yes. Ask Natalie a question. She's ready.
Natalie, I'm just curious if, these things, it's a new section of law. And I know we have like victims' rights statutes and there's things in the Kansas Constitution. And are these different? I mean, some of them I understand are more specific, but are some of them already in action? Some of them are already happening now, or kind of how, what's new, or, what's the purpose if we already have some of these things in law?
Mr. Chairman, Representative Humphreys, this would be a new section, and it would provide these folks with additional rights. As you mentioned, some of these people are already covered by, for example, KSA 74, 73, 33. that is a Bill of Rights section related to the Crime Victims Compensation Board. So that's going to be a little bit more overarching than just these people, because it would be victims of all crimes, not just sexual assault survivors, but there are some rights in there. Most victims of these crimes also have victim notification rights, which are contained in other sections. So nothing in here conflicts with any of that. This would just be additional to those rights that are already provided.
Okay, thank you.
Representative Wheeler. You are.
Perhaps your answer addressed this, but I missed it. But the Victim Rights Advocacy Office is created by Article 15 of the Kansas Constitution. That basically ensures that victims have most of these rights, as I understand it. Maybe there are some that are not. But it's a constitutional issue also. And if offices of state prosecutors are not complying with the Constitution, they need to answer for that. My mic is on, correct? Okay, that's all I have.
Mr. Chairman, Representative Wheeler, if you would like, I could print off a copy of Section 15 of Article 15 for the committee to review, if that would be helpful. I would note that the subsection B of that provision does say that the legislature may provide for other remedies to ensure adequate enforcement of this section. And it doesn't limit the legislature's ability to provide rights in statute.
Thank you, Natalie. I read Section A.
Okay, committee, it looks like some of our conferees are popping in on the screen. So we're going to get started back up with the proponents that were listed as being on WebEx. Cadence DeBias, if I'm getting that close. Cadence, you're up first. Welcome to the committee.
First and foremost, thank you so much for the opportunity to speak today. I hope that in hearing my story, I can help in building the collective narrative on the importance of HB 2536 and why myself and fellow risers are here today. When I first transferred from community college to university, I was in awe of everything in front of me. I jumped into everything I could, from social justice clubs to research work. Yet, even with these opportunities and everything ahead of me, in September of 2021, I was raped. In a new place without the comfort of what I was used to, I was scared, without support, and left looking for resources. I went to a resource center where I was asked about what I wore, if I knew the perpetrator, and about the general experience. I relived every moment, only to be told there was nothing that could be done, and given a list of rights I had so muddled with legal jargon that I didn't know what any of it said. I did know what it meant, though. There was no justice for me there. Afterwards, I was left watching my story become another file number being tossed aside to be torn up. As I left, I went down the resource number list, calling each one, only to be met with the exact same response. The number you are attempting to reach is no longer in service. At no point in my life had I felt so alone, so overwhelmed, and such like I had somehow failed. The passage of HB 2536 will take file numbers and give survivors their names back. The foundation of this bill allows for survivors' needs to be met, their justice enacted, and their resources implemented. I know what it's like to be just a number, and I know that every Kansas survivor deserves to have their name known, story heard, and justice enacted. Thank you.
Thank you. Committee, I'm going to go through all the proponents and then we'll do questions if anyone has any. So next we have Sabrina Sivert.
Correct. Can you all hear me okay?
You can, yes. Welcome to the committee.
Perfect. Thank you so much. Thank you, Chairman and committee members, for your time today and for allowing me to speak on behalf of Bill HB 2536. When I came forward about my sexual assault, I was 18 and still in high school. I was assaulted multiple times by a person of authority, a teacher of mine, and he was also a member of the local fire department that I was in a program for. For months, this person abused me. This was a person that I was supposed to have trust in and felt safe around, and he used his power to abuse me. He often made remarks saying no one would ever believe me and threatened things that meant a lot to me. My family, future career, and worst of all, my life. For almost a year, I did what I had to stay alive and safe. When I came forward, I thought things would finally stop and I'd be free. That was not the case. Even though I wasn't being raped, beat up, and verbally abused and threatened, a new pain came from coming forward. When a survivor comes forward, their world oftentimes comes crashing down with having to give statements, having doctor's appointments, people bullying and judging, and in some cases having to go through the legal system for justice, which can oftentimes be very traumatic. I had to encounter years of threats, bullying, and accusations that he was a good guy and would never do something like that. I was having to give multiple statements to the police, the school board, and oftentimes question on if I had my story correct. This made me feel so terrible, knowing they were trying to protect him and doubting me. Going through almost a year of being sexually assaulted and fighting for my life, and then having remarks and actions made like this made me feel so small, weak, and hopeless. By passing HB 2536, it would allow survivors coming forward to have rights needed to make the process easier and give them a better understanding that there is help out there and that they're not alone. The fear and process a survivor goes through can oftentimes be traumatic when sharing their assault. This bill would help protect the survivor, help them seek proper medical care, and give them rights needed to move forward after such a traumatic time. This bill would have helped me in making the process easier and helping and protecting me. It would have provided me with an advocate that was on my team. It would have helped in giving me a safe place to go when I was doubted or felt alone. This bill will help give survivors proper rights in order to move forward after a tragic time. Being a survivor is a forever fight, but if we have proper rights when seeking help and coming forward, it would make this battle we live every day a little easier and hopefully allow survivors to begin their healing process. Thank you again so much for your time and welcoming me to speak here.
Thank you. Next, we have Caitlin Ryan.
Thank you, Chairman Patton and members of the committee for allowing me to address you. My name is Caitlin Ryan, and I join today on behalf of RISE as an ally to survivors and as a woman affected by the tremors of sexual violence. On January 21st, 2017, 5 years ago, I helped organize the largest single-day mass protest in the history of the United States. The Women's March brought together women and allies from all backgrounds, political persuasions, and religions from all around the world to stand together against misogyny, against violence, and against hatred. For many of us, the Women's March helped us feel a little less alone, a little less helpless, and a little bit stronger. That same evening, as I was dismissing the last group of volunteers, one of the volunteers on my team, a man at least 30 years older than me, forcibly pulled me toward him and kissed me on the lips. I did not consent to or welcome this action. I was visibly uncomfortable and humiliated in front of other volunteers who had looked up to me that day. Suddenly, after a day of feeling so empowered, I felt alone and small, and my strength was gone. See, I'd known this feeling before. I first learned what rape was when I was 11 years old, in the 5th grade. While kicking around a soccer ball after school, my good friend confided in me that on a recent family vacation, she was raped in a hotel room. That feeling of helplessness just set in right away. My friend was in pain, and there was nothing I could do to make things right for her. It was just this sinking, powerless feeling I've felt every time since then when I've heard from another friend or a classmate or a coworker who has experienced sexual violence and has walked that long, lonely road toward justice that you've heard others describe today. But I'm here today because I know I am not helpless. We are not helpless. We can support survivors, starting by breaking down the barriers faced by survivors in the justice system. Today, survivors face immense challenges from a system that re-victimizes them when they seek basic care and justice. Today, I urge you to support HB 2536. This bill presents an opportunity to improve conditions for survivors like my childhood friend and their survivors you have heard from today. Access to justice should not depend on one zip code, and survivors everywhere deserve basic rights, such as the right to be informed of their rights as a survivor, to consult with a counselor, and to shower at no cost after an extremely intrusive examination. Through this bill, you have the opportunity to join state houses around the country and improve conditions for the more than 592,000 survivors of sexual assault in Kansas. Thank you for your time and consideration.
Thank you. Next, we have Flannery Houston.
Hello. Thank you, Chairman and committee members. My name is Flannery Houston, and I am the Director of Programs with RISE. In 2015, I was sexually assaulted by a man I was dating. As I tried to wrap my head around my trauma, I experienced a plethora of conflicting emotions. And though contacting the authorities occurred to me, justice ultimately seemed untenable. I wanted to enlist the prosecutorial support of the justice system, but was silenced by how few basic protections exist for someone like me. I was deeply aware that my case rendered itself as she said, he said, and I couldn't imagine pursuing a long road of interrogation and accusation. On top of everything, I felt shame and guilt for not coming forward. My assailant was free to attack others as I abandoned other potential casualties instead of doing whatever I could to halt the future victimization. But I simply could not fathom how legal action would make any difference. After some time and a lot of healing, I turned my focus towards what I could do to make a difference, ensuring other survivors have their civil rights protected. As a survivor, I deeply understand that we all deserve the same rights no matter where the crime took place. After my assault, I had a hard time figuring out what protections I would be afforded. Had I known that I would have had access to an advocate's support and on-hand access to information detailing my rights, I would have felt like the law was on my side. I would have felt protected from further traumatization. But none of this information was readily available to me. Survivors are left to navigate a confusing and opaque law enforcement and judicial system on their own, while at their most vulnerable. Had these protections been available to me, I would have been more empowered to report my crime. HB 2536 ensures that survivors of sexual assault will have the support of the criminal justice system that I never did. Please pass this bill. Thank you.
Thank you. Committee, any questions for our four proponents? Representative Humphreys.
Thank you, Mr. Chairman. I just have a quick question. Can someone just explain what RISE is?
Sure, I can go ahead and do that. Thank you so much, Representative, for your question. RISE is an organization that helps survivors. First of all, it's a survivor-led organization, but we help survivors on the ground in each state advocate for their rights through the Survivors' Bill of Rights.
And does RISE stand for something, and where are you located?
Thank you, Representative, for your question. RISE does not necessarily stand for anything. It's not an acronym. The headquarters are in DC, but the folks who work and volunteer for RISE are located throughout the country.
Okay. Thank you so much. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. This is an area where I do not have professional expertise and where, as far as I know, members of my family, myself, et cetera, fortunately don't have personal expertise, but it may well have happened. We simply don't know about it. But please take my question with an understanding. I'm trying to find out. If some one of our panelists could help me understand the provision regarding a free shower, I think I can appreciate the need for that, but I'm not exactly sure who provides the free shower, where it takes place. I can imagine that if we were in a medical facility, it might be one thing. On the other hand, if the victim was being interviewed at a combination police, sheriff's, and detention facility, I could imagine that the free shower might just be the same one that are used by people at a detention facility. Can somebody kind of help me understand practically how this will work and frankly, how it gets paid for?
Thank you, Representative, for your question. I can answer that as well. The bill language stipulates that if a shower is available, that the survivor should be able to shower after their forensic medical exam at no cost to the survivor. So a forensic medical exam can take up to 6 hours and can be pretty invasive. And this is, after a traumatic experience. So having the ability to take a shower after undergoing such a traumatic experience and then having all of this evidence collected from your person is really important in terms of making the survivor feel that they are safe and protected and can return to a sense of themselves after the process. I hope that answers your question.
And I certainly can appreciate the necessity, if you will, of that opportunity. So are you contemplating then, after a forensic examination in a medical facility, there would be a shower made available in that facility? Is that what we at least hope is going to happen?
Thank you for your question, Representative. Yes, that's the idea. This bill is not intended to make anything costly or reinvent the wheel, so to speak. So we're really trying to just ensure that if a shower is already available within the facility, that the survivor has the ability to use that shower and to not be charged for it.
And presumably then the survivor would be able to make their own decision as to whether or not this is a place where they would feel comfortable taking a shower or whether they would decline that opportunity.
Thank you for that distinction, Representative. Yes, that's absolutely true. We want to ensure that survivors are able to take their own agency and make choices for themselves, which is why this is simply a right that is available to them. It's not something that is mandated. We just simply want them to be able to have the opportunity to shower if they choose to do so.
Mr. Chairman, with your leave, I do have another area I'd like to ask a question or two.
Sure, go ahead.
Thank you. The bill makes good sense to me, so please don't take the fact that I ask questions as a criticism of the concept. But I can imagine in an urban area like Wichita, where I live, there are probably more resources for victims of sexual assault than there might be in a more rural community, but I don't know. How widespread or available are the types of counseling and patient advocacy services that this bill addresses? How widely are they available in 105 counties, or is it just in big cities like mine? Can you help me understand that general aspect of what I suspect is a problem?
Thank you, Representative, for your question. I am so grateful to you for asking all of these questions to clarify what is in the bill and things that may not make complete sense. So I really appreciate you asking all of these questions. That is actually an answer that I don't have for you offhand. I am happy to get that answer for you and provide it to you via email either later on today or tomorrow.
Yeah, I really don't want to put folks to that trouble unless they want to provide the information. And I don't know if we have any other panelists or any other conferees available who might be able to just give me a general idea as to what types of services might be available in places other than Wichita, where I live. Apparently not. Okay, well, thank you for answering my questions. Thank you, Mr. Chairman.
Any additional questions, committee? Okay, we will move on to our neutral conferees. Our first one is Rachel Marsh.
Good afternoon. Chairman Patton, Vice Chair Ralph, Ranking Minority Member Carmichael, and members of the committee. My name is Rachel Marsh. I'm the Chief Executive Officer of the Children's Alliance of Kansas, and I appreciate the opportunity to share our perspective on HB 2536 with you today. The Children's Alliance is a member organization made of 22 private nonprofit child welfare agencies that provide child and family services for children and families who are either involved in the child welfare system or at pretty significant risk of becoming involved in the child welfare system. So when I bring this testimony, it's pretty much from the perspective of child sexual abuse and how that does or does not fit in within the language of this bill. I'm seeking clarification around this bill as from that very important perspective of minor children who have survived sexual abuse, including teenagers. In my work, in my previous life, I started out as working with the Children's Advocacy Center in St. Louis. My very first client that I did individual therapy with was a 17-year-old child who'd been molested by her father, and they wanted to get married. On the other end of the spectrum, I did group therapy with 5- and 6-year-old children who'd been sexually abused. And so recognizing the very different experiences within that age range and having walked through since that time, cases involving children going through interviews, going through the Children's Advocacy Center forensic interview process, and then later having court prosecution proceedings and needing extra support has been something I've had the honor of doing during my career. So we do appreciate 100% and support the importance of public policy that enhances self-determination and supports for survivors of sexual assault. That's not a question for us. The question is, can all survivors of sexual assault, including minor child sexual abuse, be treated the same? So we have 3 key concerns that we'd like this committee to consider. The first one is that the definition of survivor may need further clarification. I did look up, because I'm not a criminal attorney or a defense attorney, Article 55 of Chapter 21, and I did find that sexual exploitation of a child is in that section. So that does encompass what we would consider traditionally child sexual abuse. So then if we looked further into the definition of survivor, it says if such person is a minor who is unable to consent, the survivor means the parent or other guardian. So the way I'm reading this, or one way of reading this bill, is that the parent would be substituted for the actual victim of the offense. And so for a teenage child, is that what we want? Do we want the parent to have 100% say over what they do with the investigation? And for very young children, do we want the non-offending parent to have say about whether an investigation should go forward when the non-offending parent hasn't been determined yet because we haven't had the investigation yet? I also want to raise, I mentioned it, the Children's Advocacy Centers as an important partner for child sexual abuse. They do forensics interviews, they have amazing support processes, and they're not mentioned in this bill. So I'm just seeking clarity from this committee as to whether the bill intends to include minor children of victims of sexual abuse, or simply doesn't intend to include them, but needs to be more clear on that point. Finally, underlying my point about the offending and the non-offending parent, child sexual abuse, I went back and thought about this in the morning. Of all the cases that I've worked and all the situations with children that I've seen, can I think of a case of child sexual abuse where it didn't involve a complex family dynamic? And I can't think of one. They always involve complex family dynamics. And so I think it's really important that we somehow look at this bill from not just from the perspective of the offending or non-offending parent being able to substitute their judgment and their rights about investigation, but understanding that parents and family members have such complex, confusing emotions. Even the non-offending parent, if it's an uncle, it's a brother then that has committed this dynamic. Do they want to put their brother in jail? They might not want to. They may have a domestic violence situation with that family member who committed the act. They have guilt or shame about even talking about this. These are very normal for children. It's also normal for non-offending parents. So I think we just ask you to help us clarify if this is intended to address minor victims or not. And I'm happy to stand for questions at the appropriate time.
Let's have Lindsay next, and then we'll see if we have any questions for either one of you. So Lindsay Ford's next.
Hi, good afternoon. My name's Lindsay Ford. I'm the public policy attorney with the Kansas Coalition Against Sexual and Domestic Violence. And we're here today offering neutral testimony on this bill. We are a coalition of 25 domestic violence and sexual assault service providers that provide services to victims across the state of Kansas. We have member programs to address Representative Carmichael's question that provide services in 102 of the counties in Kansas. There are only 3 that don't have coverage, but those do, we tend to try to, whenever possible, have services reach out to those areas. So we are a big fan of the bill and the intent behind the bill, but there are some issues that I think my other conferees are going to address that play out in this bill. It's not perfect, but we love the idea and the intent behind it. We love especially the idea of victims having access to additional information, more comprehensive referrals, general support in every step of the process, support that our organizations are always ready, willing, and capable of offering. And so we really do love that part of this bill. That being said, we don't provide services in a vacuum. And so when our community partners like the child advocacy centers have issues with the bill, a lot of our forensic nurses additionally also have some issues with the bill. We can't provide full support for it because there are just some things that we want to tweak and make sure that if something like this gets passed, it's passed in a way that's beneficial for all of the people who are providing services to sexual assault survivors. And with that, I'd be happy to stand for any questions.
Very good. Committee questions for either of the neutrals? Representative Carmichael.
Thank you, Mr. Chairman. Thank you, Ms. Ford, for the prompt and credible answer to my question. I certainly hope we can find a way to take care of the 2 additional counties in this state where those services are not offered. Ms. Ford made reference to concerns by forensic nurses about various things in this bill. I hope some of the upcoming conferees are going to address those concerns specifically so that we know exactly what we're talking about. But as I think back to Ms. Marsh's testimony, the question about which parent consents in the instance of minors, it causes me to hearken back to a bill that we heard in this committee and then later on the floor. And I think we found a compromise and passed several years ago that had to do with forensic evidence collection kits, which were known at the time by a prerogative, but I believe be a pejorative name. So I'm not going to use it here. But we confronted this issue then about what we do vis-a-vis parental consent in circumstances where one or more of the parents are suspects in the crime, as well as circumstances where it may have involved the brother or the sister and parents might want to cover up the facts. And so I don't know exactly what the answer to the question Ms. Marsh raised is. And so I got to turn it into a question and say, Ms. Marsh, do you have any suggestions on how we deal with those types of circumstances? Because I wasn't satisfied with the resolution that we made of that issue some years ago in the context of forensic examination kits.
Thank you so much for the question. Chairman, the very fast answer is I do not have an easy and concise response to the important question. What I would hope is that seeking through, even with discussion with committee members and proponents of the bill, we could identify, is this a minor child sexual abuse bill or is it not? And so it may be a matter of carving in or carving out minors. Or minors of a certain age, but if we are to include something related to parental rights, it has to be something that can be in the best interest of the child, just like is how we do every action and investigation related to child criminal acts.
I can certainly tell you, Ms. Marsh, that we had a hard time trying to answer that question, even in a very limited context. And so we need the help of professionals to craft the answer. But I certainly hope that if this legislation were to become law, we do not leave minors behind. That would be a travesty. Thank you.
Representative Wheeler.
Just, thank you, Mr. Chair. Just real quick for Lindsay Ford, please. These advocacy centers that you mentioned that are all across the state, are they private or publicly funded? How do they get their funding?
I believe the majority of them are nonprofits.
By grant?
Grants, primarily, I believe so, yes.
Very little tax money involved, if I understand correctly.
I'm sorry?
Very little tax money involved, if I understand correctly.
I am not really an expert on where all of the financing comes from.
All right.
I'm sorry.
I'm somewhat familiar with that.
Okay.
Thank you.
Thank you.
Representative Schreiber.
Thank you, Mr. Chairman. Kind of a follow-up with Representative Wheeler's question. I'm familiar with the Child Advocacy Center in my community in Emporia, and the city and county can provide funds to the organization as well as grants and private donations and so forth, like a nonprofit. So my question is for either Ms. March or Ms. Ford. In the bill, it talks about a sexual assault counselor and defines it that the person has to be licensed by the Behavioral Science Regulatory Board. Is that common for the advocates that are serving within those CACs across the state, or is it some other form of training that occurs for those people who work there? Thank you.
For this question, I would have to also say that I'm not certain of the answer to that. I do know that I spoke with various partners related to gathering information for this bill, one who is not a BSRB licensed person and who has performed sexual assault victim advocacy in the room, making sure that they're taken care of, making sure they feel supported. So I'm not sure whether the BSRB requirement is necessary, but I can look into that further.
Any additional questions for, oh, you want to add something, Lindsay? Come on up.
So I can't speak directly to the child advocacy centers, but as far as the BSRB licensing and sexual assault service providers, it's generally at the social worker's discretion if they want to undergo the licensing requirement or not. But they all typically have the same education and background and experience.
Okay, let's move on to opponent testimony, and we have Ed Klump.
Thank you, Mr. Chairman. My name is Ed Klump, and I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. I want to preface our testimony by saying it was difficult to decide whether we wanted to be neutral or opponent on this, but we went to the opponent because it has so many things in it that concerned us that need to be addressed. We absolutely advocate for support for all victims, including sexual assault victims, and we think getting information to them on how they can get that support is critical. We do that in a lot of cases. We have started several years ago to enhance some training called trauma-informed interviewing. And that came about actually through the work of the Sexual Assault Kit Initiative, and then was further enhanced by work that we were doing in the human trafficking area. And there is some really good training out now for law enforcement and others that have to deal with traumatized victims, whether it be sexual assault or otherwise. And so there's a lot of that being implemented in the training now in Kansas law enforcement. And so we're doing a lot of work along those lines. We believe victims need to be informed of the progress of their cases. And I think that's probably no more important than in a personal crime such as the sexual assaults. We try to do our best in that. The integrity of the investigation sometimes requires us to be a little guarded in some information we provide, which causes a little stress, but we try to do the best we can in that. So what I'd like to do is I'd like to just talk about some areas of the bill. We believe the intent of this bill is good, and we would support the general intent of it, but I want to talk about some areas of the bill that we particularly have concern with. And we'll start out in Section A on page 1. You'll notice in that it says that they have the right to consult with a sexual assault counselor and have a support person of the survivor's choosing present during any, and I'll skip down to interview by law enforcement. And we don't want to say that no interview with law enforcement, would that be appropriate? But let's take, for example, that initial contact where a uniformed officer responds to a call from a sexual assault victim, and we make that contact. There are certain things that are absolutely critical for us to gather immediately. To delay that interview by providing the rights, possibly having to explain some of those rights to people, asking them to sign a form, which is later in the bill, that we hand to them so we can prove that we handed it to them, which flies in the face of building trust. And so, for example, we might have to wait because this person has the right to have a counselor present or a support person present till we get that person there before we can ever ask questions like, what does the suspect look like? Do you know who the suspect is? Where did this happen at? Where do we need to go secure a crime scene at? And we can't afford to delay some information in that initial contact. But the way this bill is written, any interview of that victim has to be preceded with giving rights and waiting for a counselor or another person to show up. And that, we believe, is not the intent of what the proponents probably want to have happen. If you go down to the bottom of page 1, it talks about signing such a document shall be signed by the survivor. So we're going to demand that they sign this piece of paper so we can prove that we've given it to them. We have we just don't think that's the best approach to a victim when they're suffering the trauma that they are at that time. And what happens if the survivor doesn't sign it? Does that mean they haven't acknowledged their rights, so we shouldn't question them? Exactly what does that mean? If you go over to page 2, there's a provision in there that we believe is helpful, and it's on lines 7 through 9. It allows the law enforcement officer, prosecutor, or defense attorney, if they determine the presence of such a support person would be detrimental to the interview and the survivor consents to the absence of a support person. That gives us a little bit of room to maybe have some latitude in what we do with a particular person that the victim may want in the room. And I'll go to human trafficking. One of the things we frequently find in human trafficking victims is guess who they want? They want their trafficker. Are we going to let the trafficker be there because the survivor wants that person to be their support person? And I guarantee you that will happen. We see it happen repeatedly. Down at the bottom of page 2 is an area we have a huge problem with, and it starts on line 41, page 2. Upon written request of a survivor, the law enforcement officer shall furnish a complete and unaltered copy of all law enforcement reports concerning the sexual assault. There is nowhere where we provide the complete, unaltered investigative report to a victim, and that is counterproductive. It may be a time and a place where the victim learning more about it may be beneficial, but to hand over the complete report of our investigation, sometimes those reports have some very sensitive information that would be very upsetting to the victim, and could even be detrimental to people that we ultimately find out aren't even involved in the case, but initially a finger's pointed to them. And so we strongly oppose that language there. And then on page 3, you'll see that On line 12, they also have a right to retain counsel present. So that brings up yet a third party. So now we have a victim, we have a support person, we have a counselor, and we have an attorney who we have to coordinate with if we want to do a follow-up interview in this case. That's a lot of people to coordinate a schedule and do a timely investigation. And in the meantime, we may miss evidence, we may miss the opportunity to apprehend a suspect or take them into custody or question them further. And so that is a little bit of a problem too. And then finally, on page 3, lines 17 through 20, a survivor who is aggrieved by a violation of this section shall have a civil cause of action against a person who or entity that violates the provision of this act, creating civil liability if something happens that some little component of this doesn't get fulfilled. In other words, we give a form to this person at the initial contact, at the follow-up investigators contact, and then, you know, maybe there's 2 other contacts where the investigators have to come back and ask the victim about things that we learn in the investigation. So every time we're having to give the piece of paper, sign it, give the piece of paper, sign it. And if somewhere in the process that falls through the crack, we don't think it's right to create a civil liability for things like that. Now, if somebody intentionally denies some person, you know, a right to counseling and things like that, absolutely, you know, but that's not the way this is worded. It's very broad. And so, Mr. Chairman, again, I can tell you personally, as a law enforcement officer, I dealt with many sexual assault victims, and it's a very difficult thing for us. It's a very difficult thing for the victim. We see them when they are most traumatized, immediately following. I remember one case in particular, and I'll just share this with you real quickly. A female was raped by 2 males that took her outside the city, stripped her of her clothing, raped her, and then abandoned her. And she went to a house where porch light was on to get help. And we responded to that call. And she was wrapped in a blanket the people that lived at the house had given her. And the trauma that girl was suffering was just unbelievable. And we understand that, and we understand that professional counseling is needed. We need to get support for these victims just as quickly as we can. But it's also important that we not let that interfere with the speed of at least the initial investigation, so we can gather the information necessary to start the process of finding the responsible parties and bringing them to justice on behalf of these victims. So, Mr. Chairman, I'll stand for questions.
First up, we have Representative Carmichael.
Thank you, Mr. Chairman. Thank you, Mr. Klum. I know it's not easy to stand as an opponent in legislation like this, and I'm sure that we all agree that the purposes are worthy, that the so-called devil is in the details. In your testimony, you gave us the example of the victim who wants their trafficker as their representative, and even in my limited experience, I've seen that happen. As difficult as it might be for some of us to appreciate, it really does happen. The second aspect of your testimony, though, is the disclosure of all the reports to the victim. So let me pose to you the hypothetical. The victim receives all of the police reports. The police reports are then delivered to the trafficker. I presume, number one, that would almost undoubtedly adversely affect your investigation, because the people involved who are the criminals now know everything that the police know. And secondarily, that it could likely endanger the lives and welfare of witnesses who spoke to the police to identify who they saw, what they saw, particularly when they are perhaps under the control or influence of the same trafficker or the same uncle or whomever. Could you address those concerns for me?
Well, I think you're right on target with all of those concerns. I mean, there's many aspects of an investigation that if those details are revealed too soon, it really creates a problem with verifying information that people give us. Even to the extent sometimes, in crimes, we have somebody who, for whatever reason, is compelled to indicate they did a crime they didn't do. And oftentimes the tools we use to detect that when we suspect it is asking them details of the crime that we know. And if those details are released and out where people can get hold of them, then it kind of nixes the ability to do that. When we do investigations, we really have a responsibility to numerous persons. We have a very strong responsibility to the victim to bring justice to their case. But we also have a responsibility to the offenders and the accused to make sure we find all the evidence that goes either way. Sometimes we have people that are accused or are suspects in a crime that are very strong suspects that we, through our investigation, we can prove they were not involved. And that's just as important as proving somebody is involved. And so all those things are complicated when we release investigative details early. I hope that answers your question.
As a means to wave goodbye. Thank you, Mr. Plump. Thank you, Mr. Chair.
Any additional questions, committee? Okay, thank you, Ed.
Thank you, committee.
We also have written opponent testimony from the Kansas County and District Attorneys Association. Anyone else as an opponent? Okay, I'll close the hearing on House Bill 2536. Representative Hoheisel.
Thank you, Mr. Chair. I just want to say, just give the committee some insight on this. I've been working on this bill with the RISE organization for a couple of months now, and Ms. Ford as well. We shared a conference call last week, Ms. Ford and Ed Klump and I've also had another conversation with the Attorney General's office and identified some of the issues with this. And I think we all have agreed on a plan to move forward and clean up some of the language and possibly come back next year with a better product that takes in all the stakeholders' concerns. That's a candy bar there, Representative Schreiber. So that's kind of where we are on that. The reason we submitted it, we were kind of up against the wall, and we didn't get the opportunity to address the concerns of law enforcement and district attorneys associations. So we're going to keep working on this and come back with a more comprehensive product. So thank you.
I appreciate your work on this, and Representative Lynn and everyone else who's kind of joined in and worked on this. So we'll look forward to it. Now, open the hearing on House Bill 2507, and we'll have Natalie come back up to give us an overview.
Thank you, Mr. Chairman. House Bill 2507 would add denial of civil rights based on a person's disability to the crime of denial of civil rights. The bill amends KSA 216102, that's the crime of denial of civil rights. Currently, that crime is intentionally denying to another on account of race, color, ancestry, national origin, or religion of the full and equal use and enjoyment of several services. I won't read those to you, but if you have specific questions, I'm happy to answer them. This bill would add disability to that list of race, color, ancestry, national origin, or religion as a basis for denying someone civil rights that would then fall under this crime. And I can take any questions.
Do we have any questions? Representative Carmichael.
Thank you, Ms. Scott. Current state of the law, the Kansas Human Rights Commission, in response to a Supreme Court decision of now about a year ago, began to accept complaints of discrimination based upon sexual orientation, if you will. And I'm terrible about always using the right terms. But in essence said it was against the law, or they would process complaints for gay people who've been discriminated against. The current criminal statute, does it extend to gay people? Obviously, it doesn't extend to disabled people, otherwise we wouldn't need the bill.
Mr. Chairman, Representative Carmichael, sexual orientation, it does not appear in that list. Right now, it's just race, color, ancestry, national origin, or religion.
Well, this may be as good a time as any. Please draw a balloon amendment to include gay people in these protections. Thank you, Mr. Chair.
Additional questions for Natalie? Okay, thank you, Natalie. We'll move on to proponents. Martha Gabehart.
Thank you, Mr. Chairman and members of the committee for the opportunity to testify in support of House Bill 2507. The Commission on Disability Concerns makes recommendations for changes to state laws, programs, regulations, and services to help people with disabilities overcome discrimination and be able to participate in those government programs and services and live in their own communities. Frequently, people with disabilities bring issues to us to consider for bringing to the legislature for changes. This particular issue came to us from an attorney in Wichita, and the commission agreed that this was something that we probably could support without too much difficulty. Our thanks to Representative Heiberger for introducing the bill. Let's see, Natalie did a good job of describing what this is all about. We encourage the commission to pass this out favorably.
Any questions? Representative Carmichael?
Thank you, Mr. Chair. Would your organization have any objection to seeing this bill amended to protect not only disabled people, but also gay people as well?
We wouldn't have no problem with that at all.
Thank you. I presume that would be the case.
Any other questions? Okay, thank you. Committee, you also have written proponent testimony from the Kansas Council on Developmental Disabilities, the Disability Rights Center of Kansas, and InterHab. Anyone else here or online as a proponent? Okay, I don't show any written or any neutral or opponent testimony. Anyone here as a neutral or opponent? Seeing none, we'll close the hearing on House Bill 2507. That is it for today, committee. Reminder, we have 2 bill hearings tomorrow. Intend to work the bills that I've listed off to you several times. I'll do it one more time if you feel like writing them down one more time. 2496, 2527, 2537, and then hopefully we have time to get to 2154 and 102. Again, 2154 and 102 are bills we heard last year. So refresh your memories, and we'll have Natalie help us with your memory as well before we work those. Committee, Thursday, I believe the agenda is still pending, but we are going to hear House Bill 2620. That got sent to corrections yesterday, and so we had to get it referred back to us. That happened this afternoon. I just don't know that the system's quite ready for us to be able to grab it and update the agenda, but everyone should know that we're going to hear that on Thursday, and we'll get an official updated agenda out as soon as the system will allow us to do so. What is it? So that's the bill that Representative Featherston was attempting to introduce in our committee last week. It has to do creating the crime of interference with the conduct of a hospital, employees, those types of things, healthcare providers. So we'll have that one. And then we'll work more bills that day, and I'll get you that list tomorrow. That's it for today. Everybody have a good evening. I'll see you tomorrow. Thank you. We're adjourned.